Good morning, everyone. This is Rajesh Kumar. Today, we are going to see one theory question on consideration as well a problem question on the same topic. Disclaimer: the video content has been made available for informational and educational purpose only. Kindly go through the disclaimer completely. Let's start with the question. Consideration must have some economic value. We have to discuss the theory on this topic. Jin runs a Chinese restaurant and employs Carl as a waiter on weekday evenings. Jin asks Carl if he would mind cutting her lawn at the weekend, which Carl agrees to do. After Carl has cut the lawn, Jin says she is very pleased and will pay him £10 next week, which she later refuses to do. We have to advise Jin on this case. Let's start responding to the theory. Consideration must have some economic value. The issue of whether consideration has some economic value center around the principle that consideration must be sufficient but need not be adequate. This principle reflects the requirement that something of value might be exchanged between the parties for a contract to be enforceable. However, the law is lenient in determining what qualifies as value. Consideration need not be adequate, meaning the court will not examine whether the parties have exchanged items or promises of equivalent value, but it must be sufficient, meaning it has some value in eyes of law. Sufficiency versus adequacy of consideration. In English contract law, consideration must be sufficient, meaning it must have some value in the eye of law, but it does not need to be adequate. The court does not assess the fairness of consideration, nor does it require that consideration given by both the parties be equivalent in value. This was exemplified in Chappell and Co. Limited versus Nestle Co. Limited in 1960, where the court held that even chocolate wrappers could constitute a valid consideration as long as they had some value. In other words, the classic case of Chappell and Co. Limited versus Nestle Co. Limited 1960 illustrate this distinction. In this case, Nestle offered records in exchange for money and three chocolate bar wrappers. The court held that the wrappers, despite having no real economic value, were sufficient consideration because they were requested as part of the bargain. This case emphasized that the law only required consideration to be of some value, no matter how trivial. In White versus Blewett case in 1853, the court ruled that a son's promise to stop complaining to his father was not sufficient consideration to support a promise to discharge the debt, as refraining from complaining had no economic value. This demonstrated that while the value of consideration may be low, it must have some tangible or economic effect to be valid. In contrast, a promise that has no economic value will not be considered valid consideration. This principle was applied in the White case, where the court held that a son's promise to stop complaining did not constitute a good consideration because it had no economic value. So, this decision illustrates that consideration must involve some measurable benefits are determined. The situation with Jin and Carl primarily involves the concept of past consideration. Carl agreed to cut the Jin's lawn. After he completed the task, Jin promised to pay him £10, which he later refused to do. To determine whether the Carl can enforce Jin's promise, it is essential to consider whether his past act of cutting the lawn constitutes a valid consideration. The general rule in contract law is that past consideration is not valid. This means that a promise made after the completion of an act cannot easily be enforced because the act performed has already occurred before the promise. The rule was applied in Eastwood versus Kenyon in 1840 case, where a promise made after an act was found to be unenforceable because there was no prior agreement for payment. In other words, the general rule in contract law is that past consideration is not a good consideration, meaning that something done before a promise is made cannot usually be considered sufficient to form a binding contract. So this was established in the Eastwood case. The court held that promise to pay for an action that had already been done was unenforceable. In Jim's case, since Carl had already cut the lawn by the time Jim's promised to pay him, this promise appears to be based on past consideration, which typically would not support an enforceable contract. Is there any exception? Yes, there are three exceptions. The three-part test from Lampe versus Bradford is an exception to this. However, as outlined in this case and further clarified in recast a patent, in the case in 1892, the court will enforce a promise made after the performance of an act if three conditions are satisfied. First one, the act must have been performed at the request of the promiser. Both parties must have understood at the time of the request that payment would be made. A promise would have been legally enforceable had it been before the act was completed. So, in this case, Jin asked Carl to cut her lawn, which satisfied the first requirement. However, the second condition, the mutual understanding that payment would be made, is unclear. If Carl cut the lawn with no exception of payment, then promise to pay would fall under the past consideration and be unenforceable. But if there was an implicit understanding that Carl would be paid, the promise may be enforceable. The final requirement is easily satisfied as a promise of £10 would be legally enforceable if made beforehand. Thus, a Jin's liability depends on whether the call can demonstrate that work was done with the expectation of payment, making this case where the exception to past consideration applies. So in Carl's case, if Jin's promise to pay the £10 was made for an act that already occurred, then the court would first examine whether the promise meet the three-part test of past consideration. If it does, then the £10, although small, would still be regarded as a sufficient consideration, as the law does not concern itself with the fairness or equivalence of the exchange. Thus, as long as there is some form of economic value attached to the promise, it is enforceable. Let's conclude. Jane's promise to pay £10 is potentially unenforceable if it is seen as past consideration. However, if Carl's cutting of the lawn was done at the Jean's request with an implied expectation of payment, then the later promise could be enforceable under the exception outlined in Lampe and Recase patent case. Thank you.